Welcome back, members. We are through with our ruling, and Honorable Odunya is going to lead us. Ruling of the committee. Please welcome back to the session. There were several issues raised by counsel for the committee has first of all dealt with the issue of being supplied with a copy of the report of the previous petition. The committee has noted that this report was not sought by the respondents in their correspondences. Number two, the committee has also arrived at a decision that the previous petition and the current petition has different parties to it. To be more specific, the petitioner in the present petition was not a party to the petition counsel for the respondents have referred to. Number three, whereas counsel for the respondents submitted that there might have been issues that were dealt in that previous petition which may have a bearing to the current petition, so that we dispense with such issues that were dealt with in the previously filed petition. The committee has also noted that the earlier on filed petition to this county assembly, it was withdrawn without going to the substance of that petition. And therefore, there is no substantive issue that was dealt in that petition that may, or rather can be said that it would have a bearing on the present petition. The committee has also noted that, and by law, because the previous petition was withdrawn by that petitioner on his own motion, and also the counsel who are currently representing the respondents were the same counsel who are representing the respondents in that previous petition. A withdrawal of a petition does not bar filing of any other subsequent petition, even by the same petitioner. For those reasons, we hereby direct that request shall not be granted by the committee. Number two, counsel for the respondents have also alluded to the documents filed by the petitioner, and this was specifically Council Mereri, when he referred to a document filed by the petitioner, whether we can refer to it as a bundle of documents, and if at all that is the document he will be relying on. It is the ruling and direction of the committee through the chair that the committee will only rely on the documents filed by the petitioner which is in receipt of the committee. And the committee, for that reason, presumes that the bundle of document counsel for the respondent, Counsel Mereri, was referring to, that is the document that the petitioner will be relying on additionally to the petition itself. We do not have any other document other than that bundle of document, and so that is the document the committee also shall be allowing before this in these proceedings. Number 3, we have the issue of service on the mode on which the respondents were served, and the matter of an affidavit of service. This committee and the assembly, by our ruling, it is directed by parliamentary practice. This is an institutional being, and it has its own way of serving and receiving documentations. This institution is never subjected to the issue of procuring of process server, which normally happens in the normal court practice. But here we exercise parliamentary practice. Counsel for the respondents on behalf of their clients have not raised the issue of whether or not the respondents were served, but the issue in question is who served and whether they are authorized. So that is our ruling, that we are guided by parliamentary practice, and being an institution, we have our own mode of service and receiving of documentations. And therefore, once you receive the documents, those are the documents we shall proceed with this matter. We shall proceed with this matter referring to. On the issue of the copy of the Hansard for committal of this petition to the committee, we wish to notify the respondents through their counsel that we have perused through our correspondences between the committee through the assembly and counsel for the respondents, and noted that this is a matter that has arisen when counsel for the respondent Shifoka rose on his feet. Otherwise, there was no such specific request for a copy of the Hansard for the committal of the petition to this specific relevant committee. Would such specific request had been made, the committee would have indeed supplied by such a specific request of the answered report for the committal of that of the petition to this committee. For the issue of extension of time and when that is pertaining Council Mereri's request for clarification as to when the 2 days started running. And also it marries together with the request by Council Chief Walker for going way beyond and outside the standing orders for the interest and the spirit of Constitution, that we go even if we can enlarge time within which we can report to this House of our report of the report of this committee, even if it is outside 60 days. It is the committee's decision that here we practice parliamentary practices that has been established over time. When a request was made through a letter to this committee through the office of the clerk for extension of time, over 21 days, within the specific 60 days calendar days, we have to conclude the determination and giving a report to this House. We adjusted the schedule of these hearings, and at least for the fairness and for the fair administrative actions purposes, we granted 2 additional days within which the respondents are supposed to comply. The committee did not just wish away the request for the extension of time, but it saw it well to at least grant some time, and that was 2 additional days. Specifically to Council Mereri, the compliance by the respondents was to be by 27th Monday. Therefore, when an additional of 2 days was granted, automatically the 2 days falls within the Tuesday, the 28th, and the Wednesday, the 29th, which is today. The time does not start running from today, but it started running from the day, or rather time, the respondents were supposed to comply. That is why the committee, through the chair, at the introductory stage, they directed that since the preliminary objection that was filed only relates to matters of law, the hearing, the substantive hearing that was supposed to commence today was pushed to the 30th, the Thursday, which is tomorrow, for purposes of paving way today to only deal with the matters of law raised in the preliminary objection. And it was well directed that the preliminary objection may well be merited and dispose of the petition in its entirety, if at all it is merited. But only for abundance of doubt, if it is not merited, that is when the Wednesday, 29th November 2023, was included as the last day for compliance. In the event the PO is not merited, and then we proceed tomorrow, the 30th, Thursday, November 2023. The last issue was on the voluminous documents the respondents were supplied with limited time. We have well stated on this issue, but without being much repetitive, we have alluded to the fact that the committee did not just wish away your requests for purposes of your preparedness. According time is a fair administrative actions act action, and therefore within the limited timelines that we have, the committee saw it necessary to grant an additional of 2 days within which you could look at the documentations and make your responses and comply by today, close of business today evening. We believe the committee has substantially addressed each and every issue that was raised by the Respondents' Council on behalf of the respondent. And for the one reason that we need to see this petition deliberated upon, and all the issues that appertains it within the next the 60 days, we are therefore directing, having addressed all those issues, that now, without much ado, we proceed and counsel for the respondents address the issues raised in the filed preliminary objection, and counsel we are counsel for the respondents, counsel Shifuoka and counsel Mireri. You are senior to the person now speaking, and I do not need to give any advice on the issue of the PO. We restrict ourselves to matters of law. We had addressed the issue of the petitioner and his request, and it is even beyond, much beyond the 15 minutes he had requested. And now, after the Respondents' Council take 30 minutes to argue their preliminary objection, the petitioner will also have 30 minutes to respond. We shall accord the Respondents' Council also an additional of 15 minutes, the way we had directed, to make rebuttals to the petitioner's submissions. Senior Counsel Shifuoka.
Honorable Chair, we are having dysfunctional equipment before the Honorable County Assembly. I think we need to do something. We do not know what is going on. We need a decent County Assembly. These are sentiments that we presented when we are here before, that we need self-sitting places. You see, your hand can easily get stuck in this stuff. The microphones are not working. You are given a location, you can do supplementary budget. so that you also work from decent places. We do not want you to work from streets, from condemned places. So I hope the committee will raise these concerns from the service recipients who appear before you for your own welfare and the welfare of the public. These are things that we do not need to belabor. That being said,
most of life.
Yes. That being said, Mr. Chair, we respectively are taking 5 minutes to address you on issues arising out of your ruling, and that 5 minutes is to be ceded from our time for the right of rebuttal. We are apprehensive. First of all, we wish to seek the chair's indulgence and request for the supply of that ruling, type certified ruling, delivered today. We hope that you can get it by close of business. Secondly,
Council Shifoka.
Second,
Council Shifoka, the committee also respectively committed to hearing you, but this is the ruling that has been delivered by the committee. We do not know how again you want details of our ruling, because you are inviting us again to deliberate and come back to you. We are directing that unless you are going straight to the PO, we are finding it a challenge, Council Chifuoka, that you are addressing on a ruling we have delivered. I may pose a question to you. How do you want us to address on the issue now you are raising regarding our ruling? How do you wish us to address them? Ruling, that is the main question in the House. How do you want us to address those issues that you are now getting into the ruling? Now, how do you wish us to address those issues?
Now that the committee appears to desire to gag counsel for the respondents, I would wish to inquire any specific reference to any standing order that provides for service of documents from the Assembly. And any precedent by way of parliamentary practice that would authorize non-licensed, non-practicing process servers to effect service of documents.
Thank you, Council. We are not, the committee is not a party to this case. We are not fighting, and that's why I said the committee has delivered its ruling. We have substantially dealt with the issues you've raised. We are not now in another exchange on the issue, on the ruling we have delivered. That's why we have directed, let us go to the preliminary objection. You can consult with your colleagues so that, because we are not going again to discuss on the ruling we have already made. We are not going to discuss on the rule. We do not know if you are requesting us to review our ruling, if you are requesting us to sit as an appeal on the ruling we have made. That is the point I'm coming from. Now we are directing counsel that unless you are dealing with the preliminary objection as directed, we are not going to continue in that manner.
Honorable Chair.
Kindly be directed.
Honorable Chair, I am glad that by its conduct, the committee admits its ruling is made in a vacuum and in a mystery. I would wish to donate my 2 remaining minutes to counsel to raise issues that he has.
Thank you, Council. Chair and honorable members, you've just done a ruling, and it's not our intention to be perceived to be fighting your ruling. We are men and women of honor. We respect the law. We practice the law. We live by it. This is a house. This is a committee of rules, procedure, precedent, and history. All that we're asking is that if there is an ambiguity within a ruling, clarification. We always, Honorable Warunya, ask the courts to be clear with their ruling if it's ambiguous in order for the parties to execute. For instance, you've made a ruling that you are going to rely on the bundle of documents. My question then that was perhaps escaped by the committee was, are these documents which were received by the committee from the petitioner, or they are the committees? That is a question which this committee cannot escape from answering. Whose bundle of documents are we dealing with? We are not saying we do not rely on them, but we must know whose are they. Were these relayed to the committee by the petitioner and they were supplied to us? That's all we are seeking. Because if these documents do not originate from the petitioner, then, Honorable Warunya, respectively, we submit Section 35 of the Evidence Act will kick in, and the entire bundle will be thrown out of this committee's proceedings because it does not belong to him. So all we're seeking is clarity from the ruling. Whose documents are we? We are not saying the committee not to rely on the documents, but we want to know, are these the petitioner's documents? As we prepare our defense, we know how to raise issues from his documents. Then finally, Honorable Chair, the Chair has alluded to the fact that we perhaps have got so much latitude in terms of time. We are conscious, we are guided by the time you allocate to us. The time we're expending is from the allocation you gave us. We respect this committee. We believe you seated here to arbitrate, to listen to an accuser, prosecute his case against our clients. Removal from office is a matter of grave concern. It cannot be treated casually by this committee, and I'm glad Chair alluded to it, that you're sitting as an impartial arbiter to listen to the petitioner, to prosecute his case and prove grounds for removal. And to do so, justice somehow cuts both ways. It knows no petitioner, it knows no respondent. We're seeking that this committee applies itself in such manner in order for all the parties and the public, particularly the people of Kakamega. They are owed service. And those of us who are in the business of serving to the cause of justice, we feel aggrieved when we are gagged from raising issues that ordinarily would be raised. So with that, I would seek that the committee kindly clarifies. We are not saying you set aside. That will be appellate in itself, but we are seeking clarity from the ruling that you've made. So with that, we respectively submit. Thank you.
Council Mireri and Council Shifoka, I respectively respect you, and we take note of whatever issues you are raising. Number one, what the committee through the chair was directing Council Shifoka Senior is that when you raise issues that go at the heart of the ruling, you are in itself yourself telling us whether either to review or appeal, or rather make a decision as an appellate body again on a ruling we have just delivered. For that reason, that is why I was saying we do not go to the heart of the ruling, and if at all someone, any party is aggrieved by that ruling, there is another procedure again that are still available. Number two, now on the specific issue you have raised, on the issue of the bundle, because if at all the petition may not, the PO may not hold water, it is the same document you shall rely on in terms of making your responses. As directed in our ruling, that we only channeled to the respondents the documents we received from the petitioner. And the bundle you are holding, which is also in our receipt, we said that is the documents the petitioner will rely on, because that is the document we have. I have looked at the preceding paragraphs of that bundle of documents. Firstly, on the preceding pages, it is an affidavit by the petitioner. It is an affidavit by the petitioner sworn on 20th November 2023. And what follows their documentations. Whether they are his documentations or not, this is not a document of the committee or the county assembly that originated this document. These are documents originating from the petitioner. That is why we directed that it is his bundle of documents, and therefore he shall rely on it, and you shall rely on it in making your responses and during the proceedings of this matter. Kindly be well guided.
Thank you, Chair. That is clear. For the record, going down, this is the petition. We know the petition that this is the petitioners. This is what we rely on as petitioners. That is expressed several issues raised by my learned colleague.
For abundance of doubt, the committee is giving a leverage of the engagements and deliberations we have had. We again give you 30 minutes beginning right now.
The Honorable Chair, we realize that the bundle of documents attaching to an affidavit sworn by the petitioner, supposedly on 20th of October 2020, 20th of November 2023, do not meet the threshold for admission under law. We realize that all those documents, rather the copies, the attached copies of purported documents, would ordinarily be public in nature. When we look at Section 80 and Section 81 of the Evidence Act, public documents are only admissible in proceedings.
Councillor Chifoka, maybe which point of preliminary objection, which number in the notice of preliminary objection, which number is it in the preliminary objection? You will refer to us the specific as we go by. Which one are you arguing? There are a number of them, 8 of them. You will kindly refer to us now which point you are arguing.
Honorable Chair, it is obvious, and as from the reading of the notice of preliminary objection, that I'm on to number 1, unless the committee has not read through the PO.
We were just giving directions that you specifically direct us as we go by.
And Honorable Chair, I'm hoping that this interjection shall be compensated for in time.
Councillor Chifoka. Council Shufok, please let us be directed. We have had a lot of engagements and deliberations, and we have wished away the minutes we had taken. Let us just proceed.
Most obliged.
Yes.
Yes, Honorable Chair, when you look at sections 80 and 81 of the Evidence Act, Cap 80 of the laws of Kenya, the documents purportedly supplied in support of the supporting affidavit or referred to in the supporting affidavit would be ordinarily public documents. Public documents are only admissible subject to due process of acquisition, and the law is very clear. You make an application, you pay, they are certified. None of those documents is certified. Two, there is no evidence of any request of those documents by the petitioner to be supplied with those documents. Three, there is no evidence of any payment for access to those documents. This also contravenes the procedure of acquisition of public documents under section 8 and 9 of Access to Information Act. In addition, it contravenes the right to access to information as enshrined under the Constitution. Secondly, we have had the benefit of prior ruling of the committee, and we are before you. The committee cannot derive powers and procedures it does not have. When you look at your standing orders, there is no standing order that provides for such kind of proceedings. So in the absence of any direction on what rules, regulations that are to be followed in the prosecution of this petition, it then becomes prejudicial to the respondents, including provisions as to time. No standing order provides for any specific petition, attendant and regarding to members and the chair of the County Public Service Board. So in that lacuna, then you are improperly and illegally constituted to take this process. Three, we are saying, given that those documents purported to be documents of the petitioner were illegally obtained, contrary to the procedure and requirements of law, they are inadmissible and ought to be expunged from the court record, from the committee's record. The committee cannot perpetrate irregularities, illegalities, just for purposes of scoring a process. Our objection is also merited when you consider what the High Court three-judge bench has said in the case of Honorable Philomena Mwilumbete versus the Director of Public Prosecutions, the Director of Criminal Investigations, and the Chief Magistrate and Corruption Court, Nairobi. This is contained in Kenya Law Reports as petition number 295 of 2018, where the courts explicitly indicate that where evidence sought to be used against a party is illegally obtained, it becomes inadmissible, and the ordinary course for such an incident would be to throw out the rest of that evidence. And I want to believe you are bound by the decision of the High Court in treating the documents as presented. In voicing that, we also have recourse to Article 50, Sub-Article 4 of the Constitution, which adds the voice that illegally obtained evidence against any party is inadmissible if the prejudice to be occasioned on that party shall result in a miscarriage of justice. Number 4, we have an Act of Parliament known as the Oaths and Statutory Declarations Act. It's Chapter 15 of the laws of Kenya. When you look at the rules, particularly Rule 9 of the rules under that Act, the Oath and Statutory Declarations rules, it prescribes how documents in support of an affidavit ought to be presented. They must, 1, be marked. 2, endorsed with a template stamp as appears in the schedule to the Act. None of those copies of documents complies with that requirement. Remember that affidavits are solemn, and that is why the parliamentarians, now that you indicated that you are guided by parliamentary procedure, the parliamentarians in their wisdom decided to describe how an oath should look like, and any document accompanying an oath should be prepared and submitted. These documents do not comply. So still, they remain inadmissible as they contravene the provisions of the Statutory Oaths and Statutory Declarations Act. Closely, when we look at the rule, the same rule again, it prescribes that is affidavit to which the documents ought to be attached. How does it look like? 1, it must be signed by the deponent, the person who is swearing. 2, it must indicate where the oath was taken. 3, it must indicate on when the oath was taken. I'll draw you to the face of that affidavit. This affidavit in support of the petition was supposedly received by the County Assembly on 17th of November, 2023. When you go to what we call in legal terms the jurat, which is to contain the place, the date, and who swore it, you realize that this was commissioned on 20th of November, when it was already a document of the committee. Meaning, this document was received when it was inappropriate, and the committee or the secretariat facilitated an alteration of that document by imposing a date. We want to know, is it the secretariat, is it the committee that imposed a date and swore this document? And if the committee or the secretariat can do that for a party appearing before itself, whether it is not conflicted to support one of the parties. Honorable Chair, these facts are inconsistent with the law. You cannot swear after you've already given evidence. You swear before. You cannot present an affidavit that does not comply with the rules, then one of the committee members or the secretariat sneaks in to ensure that it is complied with. We know from the affidavit it was sworn at Kisumu. We know the inductions of the committee were in Kisumu. I'm not drawing anything. I invite the Honorable Committee as well to consider Standing Orders number 85 and
Honorable
201 G.
Shifoka, could you substantiate the issue that you have just said? And Council Shifoka.
I'll rephrase, Honorable
could you
Chair.
Just substantiate.
I'll rephrase my statement. Honorable Chair, it is coincidental that this affidavit was sworn in Kisumu on 20th of November 2023, after it had been filed before the Assembly on 17th of November 2023. It was said to be sworn by the petitioner, and the principal coincidence is that also the committee was inducted in Kisumu. We do not know the date that the committee was inducted in Kisumu.
That's why, Council Shifoka, I'm saying, could you substantiate?
I said it is coincidental.
And inform the committee. These are a public hearing, and inform the committee.
Yes.
What do you mean? Can you marry the committee being in Kisumu and the affidavit being commissioned in Kisumu?
Honorable Chair.
We said we are an independent arbiter. Could you substantiate and bring the connection between the committee induction in Kisumu and the document being sworn in Kisumu? Can you bring out that marriage so that we see what you are meaning?
Honorable Chair, as I stated, it is clear that as you read the petition, issues number without pagination of the petition and the documents, it becomes very challenging to refer. Yes, issues paragraph 21. Paragraph 21. Paragraph 18. The petition. Nothing is paginated. So we are still coming to that as an issue of PO. Yes. Paragraphs. I'm referring to paragraphs. There is no pagination. We cannot know. That's why we are saying we are still going to raise the issue of compliance with the regulations on how a petition should look like. Yes. It is not paginated. That is why I was referring to paragraph numbers 21, 18, 19.
So you are starting with one document.
The order doesn't matter so long as there is a reference to it. Most obliged, yeah, Honorable Chair.
And then, Council, let us just be at ease. Let us have just engagements. You've referred to us to paragraph, but I will just, for quickness, you've told us there is no pagination. I would have expected courtesy. You just even tell us the first page by way of just going through the second page, but be it as it may, proceed. You have referred us to the specific paragraph.
Your Honor, Honorable Chair and members of the committee, when we go to paragraphs 18, paragraphs 19, paragraphs 21, paragraphs 23, paragraphs 24, paragraphs 25, paragraphs 26, 27, 28, 29, 30, 33, 'were directly in issue in petitions earlier presented before the Assembly, and in respect of which the committee is yet to prepare, publish, or supply us with a report. So proceeding to make determination of the same is what we say is sub judice, because they're still pending with you. You've not assured us that that report is ready or how we can access it, despite our express application to access the same by our letter, our second letter of 27th of November 2023.
Just for purposes of being specific, you had referred us from paragraph 19 to 26. That is 26.
21, 18, 19. Do I repeat all the paragraphs?
Just for the purposes so that we do not lose out when we are making our decision.
Okay. Just a moment. I'll present to you again paragraph numbers 21, paragraphs number 18, paragraphs number 19, paragraphs number 23, paragraphs number 24, paragraphs number 25, paragraphs number 26, 27, paragraphs number 28, no, not 28, paragraphs number 20. Yes, paragraphs number 28, paragraphs number 30, paragraphs number 29, paragraphs number 33, 34, yes, and 34.
We are well guided. We are well.
All those are directly in issue in the pending petitions that you are to make a report over the same, and therefore addressing them in these particular proceedings would be in contravention of your standing orders number 85 and 201G on safeguard to the rule against sub judice. On the sixth issue, I think we've already addressed the issue of compliance of form and content. And we are saying, in the form in which this petition is presented, blatant non-conformance to your own rules and express laws, then it becomes an abuse of process. it becomes a political tool. It becomes an item to score, to settle differences. And we are saying that the illegality in the process of obtaining these documents, then also in relation to Section 120 of the Evidence Act, if the committee were to rule otherwise, it will be necessary that it is stopped by law from doing that. We also want to refer you to those documents. Now, the problem is that the substantive documents are not paginated. They are not identified. But in brief, you will realize that most of these documents were requested for by the County Assembly on 16th of November 2023. They were supplied and received by the County Assembly on 17th of November 2023. And similarly, in coincidence, pure coincidence, the same documents that were received by the County Assembly, bearing the County Assembly stamp of receipt, they appear on the documents sworn or attached the affidavit sworn by the petitioner. The only logical conclusion is the County Assembly asked for these documents, received them, issued them to the petitioner then presented his supporting affidavit. And that is why we are saying it is conflicted if by that interpretation and movement of documents, it remains the position. Because it beats logic and law and process that documents are obtained without any letter from the petitioner, without payment by the petitioner. They are received the County Assembly. All of a sudden, these documents then are attached to an affidavit by the petitioner. And that is why we are saying either one of you, the committee members, or the secretariat has been aiding the petitioner in the presentation of the allegations before the same committee. Those are hallmarks and dangerous dens for conflict of interest. And that is why we were asking, are these documents the committee's documents or the petitioner's documents? And if they're the petitioner's documents, how is it that they bore the County Assembly stamp before the petitioner accessed them? Honorable members and chair, you realize that most of the elements of our preliminary objection have been raised. The only plea upon the documents having been struck out is to leave the affidavit naked without any supporting document. And with the affidavit being naked, then a petition cannot be supported with a naked affidavit. It ought to be struck out. I'll cede my remaining 9 minutes to honorable colleague, Mr. Mirieri. Thank you.
Thank you, Honorable Shufoka, and kindly be guided. It is remaining 2 minutes, 2.5 minutes, not 6 minutes, not 9 minutes.
Thank you, Chair. But the interjections are too many. Maybe just an additional 3 minutes here.
Please, when the time expires, we shall see what to do.
Most obliged. Thank you. Thank you, Mr. Chair.
Thank you, Chair, and the committee. Again, I really want to invite the committee and the public to the fact that this is not a war. We are here to listen to the petitioner prosecute his case and the defense to do its part, and let the committee make a decision on where the chips fall. The petition presented before this committee raises issues, which issues border on injuring the standing and reputation of our clients. It therefore cannot be overemphasized that the burden falls on the petitioner to discharge his duty of prosecuting this petition and support it. In support of our PO, among the issues we have raised is the inadmissibility of the documents. As a team, we've looked at the supporting affidavit. It doesn't say that he works for the County Public Service Board of Kakamega. To that extent, he could not be the maker of those documents. We are aware that the right to access to information entitles any citizen, pursuant to Article 33 of the Constitution of Kenya 2010, to receive any information from state or any other person if that information should be in pursuit of enforcement of a right. The petitioner is pursuing his right as a Kenyan. But how he must obtain those documents is provided for by law. And unfortunately, that law does not exclude this committee. It binds all citizens, including foreigners who fall within the territory of this republic. Consequently,
So sorry, Councillor Mereri,
yes,
we are now 30.5 minutes. I am additionally, having consulted, we are adding you a minimum of 3 minutes
thank you for your kindness.
to 1:56 p.m.
Thank you
It
for
is
your kindness.
1:52.
We will keep the time. So, Honorable Committee, it is our case that we will be proceeding once this committee pronounces itself on the inadmissibility of the volumes of documents, that we will be listening to the petitioner prosecute his case on his affidavit, which affidavit, again, we have demonstrated is inconsistent with the Oaths and Statutory Declarations Act. We do not intend to infer any ill will on anyone, any member of the committee, but we are asking, justice is asking these questions. A document is received on the 17th. The document backpedals itself to where it originated for correction of allegedly an error that was omitted at the time of presentation. Never mind that this petition refers to some documents obtained as early as March 2023, meaning, and that is our case, that somebody not within this hallowed chambers prepared this petition, and the petitioner before this committee is a surrogate of that person, and is intent on prosecuting a petition that is bad in law, a petition that is inconsistent with the provisions of the Evidence Act, a petition that is inconsistent with the provisions of these own houses' standing orders. We beseech and request this committee to have the guts to be the men and women of honor, to strike this petition out, save this great county time to do the business for which the people of Kakamega expect this committee to do. We so respectfully submit that you admit and find our preliminary objection merited and bring these proceedings to a closure. We so submit. Thank you.
construed that we, in any way, as the committee assisting the petition. But we leave it blanketly that way. The petitioner, being a layman, we do not want to see that situation whereby we are being led into factuation. If you will allow, counsel are representing the respondents, we have specific issues we've raised in the preliminary objection filed in this assembly. We shall be directing the petitioner to a point of law that you have raised so that he can rebut, so that we are not allowing him to get us into factual issues, if you may allow. Council Shifoka, do you have any comment?
Honorable Chair,
Honorable Chair, I do not know whether that is provided for in the standing orders or any of the laws you specified to be guiding your operations. And secondly, as earlier we took directions, the petitioner made a declaration that he only needs 10 minutes. He'll be ready to respond to those issues. So by his own declaration, he is precluded by doctrine of estoppel from seeking your guidance. He knows the law, he can distinguish from facts. And if he goes astray, then it is your duty as a committee to tell him you're telling us facts, tell us the law. The law is clear.
I believe we are in tandem, we are in harmony with that. And so the petitioner, you can take your stand. And please, there are enumerated points of law raised from number 1 to number 8. Deal with them respectively.
yes, thank you very much, our chair and the honorable members. I will oppose the preliminary objection, and I will want to guide our colleagues who have done law to take pens and papers to record the dates. I'm going to explain to them how I got this information, not from the county assembly. For a fact, these are public documents. And when we look at those documents, what you could be raising is if those documents are authentic. So I want to oppose the preliminary objection, and I've scribbled it down, Mr. Chair, because I only took 15 minutes. I've scribbled it down so that I save on time. And the issues raised.
Let us have these, the petitioner. Can you make your response to number 1, the point number 1 in the notice of preliminary objection? We are at 1.5 minutes, so can you?
I think because I'm not a lawyer, I summarized, and I will explain to the committee that I'm opposing this preliminary objection.
Please proceed.
Okay. The issues raised are facts grounded on lies, which does not represent the truth, and I will explain that. My petition complies with the law under Article 37 of the Constitution of Kenya. Section 15 of the County Government Act allows County Assembly to receive petitions from any person, including me, not as a person. And Section 3 of the petition to County Assembly's procedure.
Please remind us of the first section you referred
Section
to.
15 of the County Government Act.
What does it direct us to do?
It allows County Assembly to receive petitions from any person.
Thank you. Let's proceed.
Then under Section 3 of the Petition to County Assembly's Procedure Act, the petition concerns the issue where the County Assembly has power to remove from office members serving in the County Public Service Board. This is a power given by Section 58(5) of the County Government Act. The removal from office can only be done by the members of the County Assembly. I have no way reaching members of the County Assembly to act other than coming to this committee and coming to this house. The other issues raised in the preliminary objection are allegations being made from the bar advocate without evidence and require evidence to be verified. And though I am not a lawyer, I think a preliminary objection is pure legal point that does not require evidence. I presented my petition, that's why I want Mr. Shifoka to write. I presented my petition dated 12th 10/2023 to the County Assembly of Kakamega. On 15th 11/2023, I received communication to provide evidence on my petition through phone on 20th 11.
Please let us so that we are at bar with the
Am I moving too fast?
colleagues. You said you presented the petition.
I presented my petition dated 12th of 10th 2023 to the County Assembly of Kakamega. I presented my petition, not 6th, on 12th 10th 2023 to the County Assembly of Kakamega. October. That's the 12th. 12/10. That's the 10th of October. Thank you. And on 15th November, I received communication to provide evidence on my petition through a phone call. And before on 20th 11/2023, on 20th November, I took my affidavit to even date to the assembly together with the bundle of documents and a list of documentary evidence. Yes. Oh, you're writing, huh? So where do I go back? Where do I go?
What did you go to?
15th of November. November 2023. I received November. I received communication to provide evidence on my petition. You're on phone. I have the number, but I can verify to provide evidence on my petition through a phone. Yeah.
Let us give him ample time, and if at all any member wishes to raise an issue, go through the chair. Let us proceed.
Chair, if there is anything, if there is anybody I've left behind this, I told you I'm not a lawyer, a computer scientist by profession. Can I read?
And then you are giving us a detailed account of what you are doing.
Yes.
You see, council have presented here legal issues.
Yes.
Don't take us to an account of what you are doing each and every day. That is why I had directed, could you lead us to each and every
Was just
PO? So let us not go into factual. You've indeed informed the committee. A PO is only a point of law.
Chair.
So let's not go into factual, please.
Chair to fact.
Yes.
Interest. The allegation was okay.
Please clear that issue. You had gone into details, but now that is what we want. You got direct and clear.
So I wanted to state that I obtained this document legally. They are authentic. My affidavit contains my evidence. The document are further proof, and I'm also ready to give oral testimony. Standing orders of County Assembly says that, but you will guide me. Standing orders of County Assembly says that petition to be heard by committee, then committee to consider petition and makes a report, which is then tabled in the House, and a letter outcome to petition is given to the petitioner. You will guide me if I'm going against the standing orders, because the issues raised by, okay.
give the petitioner his time. You only have 30 minutes. Yeah.
I told you I stand.
You can raise that during the ruling.
Yeah, but you want specific standing orders.
We have a very limited time and we are patiently waiting.
Okay, I can just proceed, but I'll come back and look at the standing orders. When I was looking behind, when you had raised, even to prosecute on the preliminary objection was just an issue. I'm sure you had to take back. This is not a court of law, and I want them to understand that this is not a court of law. Procedures in a court of law are not relevant to standing orders.
Please be guided that if you are not sure of any matter, please you should not go into it, because we understand this is not a court of law, but a decision of this house is an equivalent to that of a high court.
I was just referring to the standing order does not provide for preliminary objection, but I stand to be guided. The committee has given a schedule of hearing. Let the committee hear me. Let the committee hear me as the petitioner, because I'm representing a lot of people behind me. And that is the residents of Kakamega County. Those for and against and prepare its report, the committee will be abdicated its duties if it declined to hear if it declines to hear me because of the allegation in the PO. It will be denying assembly its constitutional powers and duty to hear and determine issues in the mandate. Section 3 of the Petitions to County Assembly Procedures Act says that a petition is not to contain any affidavit. But my petition, they are lodged pursuant to Standing Order 215, did not contain an affidavit. My petition did not contain an affidavit.
Refers to the previous section, section 3 of
Section 3 of the Petition of County Assembly Procedures Act says that a petition is not to contain any affidavit. Sorry? Can I proceed, Mr. Chair?
Yes, proceed.
My petition, therefore, lodged pursuant to Standing Order 215, did not contain an affidavit. It is to consider a proposal. It is not a petition or a motion to remove. A power given only to MCS acting through a Section 15 and Standing Order number 64, which is not the case here. The outcome of my petition can only result in a report to be tabled in the Assembly. What the MCS will do with such a report is speculative. A petition to consider a proposal over a matter is different from performing the duty. Mine is like an inquiry. Actual removal can only be done through a vote by all members under Standing Order number 64, and not this committee through a petition under Standing Order number 15. The lawyer should advise his clients, because most of even what I've seen, what he has raised.
Petitioner.
Yes, sir.
Don't address the issue of the lawyer advising client. Stick to the main points of law.
Thank you very much. And also, maybe I would like to stop there. And
Yes, proceed.
Thank you, Chair. I think, I don't know, although the petitioner has said is stopping there. No, the preliminary objections were specific to 8. Have you exhausted the entire 8? Because yours was more of a summary, so we don't know whether you are answering number 2, number 9, but you said you have scribbled. But what I was listening to you, you are reading something. You are reading from a phone. So no, my question is straight. Have you exhausted all the? You have exhausted all the 8. Okay.
I am concerned, the petitioner, I am concerned that when we are retiring to go and prepare the committee's ruling, please, I want to refer you to point number it is a matter of law, and which was also raised by Council Shifoka on the issue of jurat of your affidavit. Can you shed some light on it? Then we, from after you answer that, Council for the respondents, we shall give you a further 15 minutes to now respond back to what the petitioner has submitted. By jurat, we are referring to the point where you signed on your affidavit. Look at your affidavit. We can see it was commissioned, and the committee has taken with a lot of concern when Council said that it was commissioned in Kisumu, and also the committee was inducted in Kisumu over the same petition. By any chance, let us be specific, so that when we are writing our ruling, we are clear, our conscience. Was this? Did you sign this document in Kisumu at the same place where Council Shifoka, I am directing you. I'm giving the committee's directions. Council Shifoka, please, can you take your seat? The committee. Thank you. We are totally concerned as a committee because you are the one who raised, and it goes to the root of our reputation and the reputation of this committee. That you said, Council Shifoka, when you are submitting, please take your seat. Please take your seat. Please take your seat, Council Shifoka. Please take your seat. Please take your seat. Please take your seat. I am the one who has raised this issue through the chair so that we leave our conscience clear. Council raised, when he was submitting, that this affidavit was sworn in Kisumu. Coincidentally, the committee was being inducted in Kisumu. This is not a matter to wish away. Did you sign that affidavit at any place where the committee was being inducted? That is my concern and the concern of the committee, so that we proceed.
I want to say no, and I want to say it in a way that you will understand. For your information, I didn't know the committee members up to today. I've never known that even for the Honorable Chair.
Councillor Shifoka, it is an inquiry from the committee. Please, you are not a friend of the committee.
The questions the committee is asking are embarrassing to the committee.
Councillor Shifoka, you are the one who raised, and you want to leave it. You want to leave. Please, Councillor Shifoka.
Why do you insist?
Councillor Shifoka, sit down. Councillor Shifoka, sit down. And that's why we are not exchanging. You have said, please, Councillor Shifoka, I am the one who is directing you. The chair has given me the powers of the microphone.
We are here as well to help the committee, not to get itself to embarrassing situations.
Councillor Shifoka, that's why we don't want to live with mad faces. And that is why we must clear our conscience. You cannot raise such an issue. This matter is being conducted in public. And when the public goes outside, it shall remain with the committee members. You cannot raise an issue, and as an arbiter, we are affected, and then you want us to wish it away. Thank you, petitioner, for answering that question. I am now giving you 15 minutes to respond to what the petitioner has submitted.
Thank you very much, Your Honor. To our Honorable Chair, Honorable Members, and my colleague, Honorable Limuli. Yes, thank you very much, Honorable Chair, Honorable Vice Chair, and the committee members. I'll start off with the issue the petitioner, Mr. Dennis Duncan Mohanda, bites his finger and shoots himself in the arm by saying the standing orders do not provide for preliminary objections on points of law. Laws are there to guide us, to ensure that we live in an orderly situation. And if there is any submission that is before you that does not comply with any law, then you are under obligation to protect that law. Importantly, neither do the standing orders provide for the removal of the County Public Service Board members. So if the petitioner were to stand his ground and say the petitioner did not provide for POs, then where do you gain the procedure to remove County Public Service members? Equally, the petition to County Assembly Act, the County Assembly, the petition to County Assemblies Procedure Act of 2020 has no provision for any petitions regarding County Public Service Board members then provided for. Anyway, let me not guide you. Under Section 3 of that Act, when you look at non-provision of an affidavit at the time, it is at the time of filing the petition. And that is why the petitioner has to go through the process, then evidence is called for. You only present evidence through an affidavit. This affidavit must be compliant to all the laws. His affidavit does not comply with any law. And that is why you're saying it should be struck out. If that is the evidence the committee wants to rely on, or the petitioner wants the committee to rely on, it should then be struck out, with the effect that the petition remains naked, without evidence, and ripe for being struck out to save the committee's time. When you look at Section 6 of the Petitions to County Assemblies Procedure Act, it is required for the maintenance of a register of petitions. My learned colleague, Honorable Indimuli, will indicate to you that the essence of a register is to serialize everything that comes in. This petition does not even have a number. It does not comply with Section 6.
Let us, Council, let us stick to rebutting to what he raised.
He said his petition complies.
Yes.
And I'm saying it does not comply because it does not even have a serial number. Hatujui ilitoka wapi? Ama ni namba gani? So we are saying, yes, the committee and the county assembly has constitutional mandate to deliver, but not in abusing process. Such are the things that abuse the process of committees, abuse schedules, misdirect you to things that you should not be doing. And we are saying anything presented before any forum that abuses both the process and the substance does not merit your attention. You strike it out. He will have another time anyway to present any other petition if you strike it out as early as this. Honorable members, we hope that as you write your ruling, you shall be well guided by our submissions and his submissions. More importantly, you shall be guided by the law and the standing orders, so that the ruling that comes out is the ruling that is going to sustain your dignity, save republic resources, to enable us move forward as a people. We submit and caution that the substantive issues raised in the POs are not things to be rushed through, are not things to be wished away, are not things to be carelessly handled. They need deep thought, wisdom. You can refer to legal advice, and we trust that there is good amount of legal resources that you will invoke for purpose of delivering a ruling that is decent and just. I'll cede my remaining 4 minutes to Council Mirieri. Thank you, Your Honor.
Thank you, Chair. Once again, we invite
Council, we are sorry, proceed. We were consulting in low tones here, proceed.
No worries. I took notice of that. Thank you. Once again, we are imploring on this committee to take note that the petitioner did not canvass any of the issues raised in our PO. None. He took this committee through a litany of what he did, what he did not do, but he never raised any issue against our PO and the points of law therein. Effectively, our PO, apart from the fact that the petitioner said he opposes it, has not been canvassed. Again, We are all concerned, just like these honorable members of this committee are concerned, that when something touches on your person, you are standing as a committee before the public out there. And that's why I think the issue that Honorable Warunya wanted clarified on the Churat was critical, because we do not want to be seen to have inferred any ill will on any of you or any conduct on any of you. I believe my learned counsel was only expressing the coincidence of happenings. Again, we reiterate that failure to comply with the Access to Information Act of 2016, and in particular Section 4, by the petitioner in accessing, owning, and delivering these documents to this committee makes the documents extremely inadmissible, to the extent that this committee sits as a quasi-judicial body. The petitioner has informed this honorable committee that this is not a court of law. Indeed, we might not be sitting under the arms of the judiciary, but this committee is clothed with the powers equivalent to a court. And that is why it can entertain motions and points of law and be properly guided. I respect and submit that indeed democracy is at play before this very committee. But democracy is not unlimited. To exercise his right to petition, you petition against persons, men and women of honor, some who have worked their entire lives to be where they are with the names they have built. I take exception to the fact that this committee is also concerned that its reputation does not get injured. Then this committee can imagine what it means for our clients. Not the first time under 6 months. Actually, 6 months should have elapsed on the 19th of November. They are back again here, accused of the same things that were thrown before this committee less than 6 months earlier. We submit that this honorable committee lives to the billing of the calling, finds our preliminary objection merited, throw this petition in its entirety to where it rightfully belongs, the dustbin. It is an abuse. It's an abuse of this committee's process. And we submit that anything that has been illegally obtained suffers the fate of an illegality, and I am sure Honorable Warunya would be effectively informing the committee that if you steal from me and the money that you stole from me is stolen from you by Honorable Buka, then you cannot go to court and claim that Honorable Buka has stolen from you, because what you have is a baby that has been born out of an illegality. So it suffers the same fate. Consequently, and I like the fact that the petitioner was telling us to be more read when to inform the petitioner. We are thoroughly read. We stand before you, honored to be part of this process, that we are fixing our democracy, we are fixing our institutions, and as we do so, we be men and women of honor and courage. Where we have to cut the chaff, we do so, and call out those things that we must be called out. So we respectively implore on this committee to do the one just thing, to find our PO merited. It has not been canvassed. It has not even been contradicted. And so, if it so finds, and I would urge the petitioner to go back to the basics.
Into any office, you steal documents through using backdoors and present them before a court of law or a judicial document body. If he legitimately and procedurally obtained
Counsel,
them, let him prove it.
Counsel, we've actually had you.
Yes.
Yeah, we've.
That is all.
we have
So they
had
are
you.
not in public domain. Bottom line. And they're not that fair.
We have had the respective submissions and argument by both sides from the respondents and the petitioner. The committee now wishes to give directions, bearing in mind our earlier sentiments, the committee's earlier sentiments that we act within very hard, strict timelines. The committee is retiring to make its ruling on the preliminary objection that has just been argued out. And we urge the parties to come back in the plenary at 4:30 p.m. for purposes of delivery of the committee's ruling. We have pushed it to 4:30 because we know that the issues raised are quite engaging, and we need a little bit time as a committee to consult amongst ourselves, to consult the relevant laws and statutes before arriving at a desired decision. So we shall come back at 4:30 p.m. for delivery of the committee's ruling. I hand over back to the chair to conclude.
Thank you very much, Honorable Walunya. I think we've actually had a productive hearing from both sides. To now actually be time for us to go, sit down, put our minds together, and do justice. This is why we have actually decided that you give us some time. It's about 2 hours from now, about 2 hours, yeah, for us to be able to make the ruling. For that matter, we are going to adjourn, and I'd like somebody to propose, and then another one to second, so that we can have that time.
Now that you had issued directions that irrespective of the moment the ruling is delivered, if it's thrown out, well and good. If it's sustained, we have other directions. Why don't we just have it tomorrow morning? We know that we have deadlines that we have to meet before close of business today, and we really are trying to make sure that we comply with those deadlines. So if we are to be back here by 4:30, then we would not be in position to do that. So that we just free ourselves for the day. You have your time to freshen, have a meal, prepare for the ruling. As you come in the morning, we shall be ready to proceed with all the compliances. Otherwise, if we come here 4:30 again, before we comply, it will be another story altogether.
Thank you, Councillor Shifoka. And hopefully you have consulted widely with your colleagues. And we are retreating to write a ruling. And also you have raised a pertinent issue in terms of compliance. And when we were beginning, we said, before us, we have a preliminary objection, before which any other thing cannot be dealt with. There are two options. The PO may be merited. It disposes of the entire petition. The second alternative and option, the PO, if not found merited, we have to proceed. The question would be, and we want ourselves to adjust ourselves. If the PO collapses the main petition, we go our ways to Kisema Asante. But if at all it will be the other option, and if we render the decision in the morning, hopefully because the hearing of the main petition had been pushed up to tomorrow, if at all the petition will not be merited. I'm being categorical with my wordings. If at all it will be in the eventual of the other option, hopefully with your request that we just come back tomorrow morning for delivery of the ruling, if at all it is eventuality, its eventuality is on the second option, you shall be ready to proceed. If at all that is it from your side, and then well said, we may come back tomorrow for the delivery of the ruling, and this one has to be very early if at all we are agreeable at 8:30, between the range of 8:30 and 9 a.m. Back to you, Councillor Shifoka. Agreeable?
I have instructions from I have instructions from my clients, and as well having consulted with my colleagues, we do feel that the issues raised are weighty, they're not to be rushed through. We want to give you time. Irrespective of wherever the PO goes, we should be ready for the next proceedings tomorrow morning.
We are well.
Unless the petitioner has reservations, we would also consider his interests.
No, it was we were talking this on your application, and we were adjusting ourselves so that we can see in the best interest of what we can do. So for that reason, so the committee is in agreement that let's come back tomorrow at the period of 8:30, 9 a.m. for the delivery of the ruling and further directions in this matter. Chair, back to you.
Yeah, but we are not actually going to have the meeting here because our departed colleague will be having a mass here in the morning. So I request that we go to the IG where you were in the morning. We do our hearings from there tomorrow. Time I think remains the same, 8:30, 9. That should be the time we should be making the ruling. With those many, I'd like actually to thank both sides, the petitioner and the board, for honoring today's hearing. And for that matter, we'd like actually to end. And I want one of the members to propose, another to. Yeah, so for that matter, I'd like actually one of the members to propose. Mheshimiwa Ndiro, you have proposed.
Okay, I second.
Okay, the meeting stands adjourned. Thank you very much. See you tomorrow.